My name is Joan Pretty. I'm an attorney and the executive director of Project SAFE, the Domestic Violence Center here in Athens.
My name is Ben Macon. I'm one of the magistrate court judges in Athens, Clarke County.
Ben, you and I have had a lot of discussions since you became a judge about the intersection of domestic violence and the courtroom. And one of the things that you mentioned early on that I thought was interesting was how your role as a magistrate is really quite different from other roles that you've had, say, as a practicing attorney. Why don't you talk about that?
Well, as a practicing attorney, if you make a poor strategic choice or handle a case in a poor manner, usually there's a pretty direct and immediate impact that you see and feel for your client. As a judge, you certainly can make poor choices and handle cases in a less than ideal way, but you may not see the consequences of that at least in the near future. And that makes it difficult to reflect on the quality of the work that you're doing. And then if you couple that with magistrate court, where in the criminal realm, we don't see the outcome of the cases. We may sign an arrest warrant, we may set a bond, but the case goes on to be indicted or not indicted, to be resolved by trial or plea. The defendant goes on to follow their bond conditions or not, and we never know any of that. And that makes it hard, again, to reflect on the quality of your work. It's sort of like planting a seed and never finding out if anything grows. Magistrate court also has the unique facet of having to move very important decisions along very quickly, where we cannot wait for days or weeks or months to decide whether to issue a warrant, and we can't wait days or weeks or months to decide whether to set bond in a case. The decisions have to be made, in most cases, very rapidly. And there's another series of very important decisions waiting right behind those. So if you sort of take together the fact that we don't see the outcomes of the cases and that the decisions have to be made so rapidly, it becomes very difficult to reflect on the quality of the work that you were doing as a magistrate court judge.
Well, let's talk about where the role of the magistrate usually begins in domestic violence, and that's right after arrest.
Right. In most jurisdictions, a magistrate court judge will see the defendant very quickly after arrest. In domestic violence cases, this means that we might see a defendant within mere hours of the incident having occurred. By law, a magistrate court judge has to consider a number of factors in deciding whether or not to set bond. The state of Georgia has also asked magistrate court judges to pay special attention to what they call the exigencies of each case, which means to me the unique circumstances of each case. We are called upon to do that, but there's not a lot of direction from there. So, Joan, I guess my question for you would be, what are those unique circumstances and how should we consider those?
Right. So certainly sometimes you'll have obvious clues. You'll have the severity of the crime itself, or you'll have serious injury to the victim, or perhaps you'll have a case where you've seen these people many times before. And so those I would all kind of lump together as fairly obvious or easy circumstances to consider. But domestic violence usually isn't obvious or easy. And so this is really where lethality factor analysis comes in. These are conditions or circumstances which have been shown through research to indicate a greater likelihood of serious injury or death. And you can see lots of different lethality factor instruments. Some of them have distilled them down to a very few factors. Some of them are quite lengthy. I like to focus on a hit parade of about 15 factors. And the way my mind works, I like to organize them into three categories: quantitative, qualitative, and environmental. And so the quantitative lethality factors all have to do with the severity or the frequency of the violence that's occurring. And so on that list we would include strangulation or attempted strangulation, sexual assault or attempted sexual assault, an escalation or an increase in the violence, threats to kill, access to firearms and pet abuse. And with some of these, you can kind of tell just by hearing the list: strangulation, sexual assault, abuse of pets. These aren't garden variety ways to hurt someone. They're really demonstrations of power and of a willingness to assert power and control. And that's an indicator of the type of domestic violence that may be going on in the relationship. That is, that it is intimate terrorism, the more rare but serious kind of domestic violence, as opposed to situational couple violence that's more episodic or isolated, tends to happen more frequently, but tends to not lead to serious injury or death. The next category is qualitative lethality factors, and this really has to do more with the power and control that's at issue in the relationship. And so here we've got controlling or jealous behavior. And jealousy is interesting. It's what we call a red flag or an early warning sign of the potential for domestic violence. But what elevates it to a lethality factor is the intensity of the jealousy, the extreme nature of the jealousy. The abusive person sees the victim speaking to another person at a party or a gathering, and they must be having an affair. Of course it's happening. And then along with that extreme jealousy is often controlling or monitoring type behavior. So checking someone's cell phone, checking someone's email or other kinds of accounts, following someone, looking at the odometer or the gas usage on the vehicle, timing somebody when they're expected to be home, or even rule-making type behavior, not allowing someone to leave or engage in activities that they used to engage in. So those things tend to go hand in hand with the extreme form of jealousy that is a lethality factor. Then stalking or harassing type behavior is another qualitative lethality factor. And I think we most often think of that as occurring after the relationship is over. And certainly we see domestic violence continuing after a relationship is over, even lethal domestic violence. But stalking can occur during the relationship too. Someone can be contacted frequently at work or school, followed around, that sort of thing. There's something else that's interesting about stalking. In 2012, T.K. Logan at the University of Kentucky led a study about the effectiveness of temporary protective orders. And what they found doing 6-month follow-up is that across the board, temporary protective orders really were quite effective at either eliminating altogether or at least reducing domestic violence. They only found one factor that was statistically significant in terms of predicting that TPOs would be violated, and that one thing was stalking. If there was stalking behavior prior to the issuance of the TPO, there was a much greater likelihood that that order would not be followed. Another qualitative lethality factor is the victim's efforts to leave or sever the relationship, which could take the form of moving out, moving on with a new partner, filing for a temporary protective order, filing for divorce, perhaps even just planning or threatening to leave the relationship. Another one is depression or thoughts of suicide on the part of the abusive person. That's quite a significant lethality factor. And then the last one on the qualitative list is the victim's terror. People who've experienced domestic violence are not very good at judging their own safety quite often. That is, they may believe that they can handle it or that the abuser really isn't that dangerous, and they might miss the mark in that analysis. But victims of domestic violence are frighteningly accurate when it comes to predicting their own death. When someone who has experienced domestic violence believes that she or he is going to be killed by the partner, we all need to pay attention and take notice, even if we don't see other signs, because these folks really are tragically accurate in those sorts of predictions. So not mild concern, not a little bit of fear, but when someone is terrified of their partner, that is a very significant lethality factor. And then the last group of lethality factors are environmental. And this really has to do with the broader landscape that the relationship is occurring in. And so here we've got pregnancy on the part of the victim. People are often surprised by this. They think, my gosh, if the victim is pregnant with the abuser's child, this should be a time of happiness, of joy. But because the victim's body, hormones, moods, attention is all turned more toward the child growing within her than the abuser, that can be a very threatening kind of dynamic. And so we often see abuse beginning during pregnancy or escalating significantly during pregnancy. Substance abuse is also a lethality factor, as is unemployment on the part of the abusive partner. And then access to the victim, what we call the oh duh lethality factor, because it's so easy to forget about it. But someone who is easily within reach, say living with the abusive partner, is in greater danger than someone who has gotten away. Someone who's gotten away but is still known in terms of whereabouts is perhaps in more danger than someone who's gotten away to a confidential shelter or some other location that the abuser isn't aware of.
Now, as I listen to those factors, my thought is I can't think of a case that's come in for bond hearing that didn't have at least a couple of those.
Right.
So are there some that are more important than others, or is there a way to categorize within those factors?
Sure. So that's a great point. And I think the first thing that we have to start with is the fact that these are domestic violence lethality factors. And some of those conditions we could find in a nonviolent relationship, unemployment or substance abuse or depression or pregnancy. And so we've got to be careful that our starting place is knowing that there's already domestic violence before we think about the factors. But once we get over that hurdle, then there's really three ways that we can go about this. One is to just count up the elements. The average number of lethality factors for a victim of domestic violence who's murdered is 7. So when you start to have more of these in the same case, your concern should certainly grow, and when you approach 7 or get beyond it, that should be really pretty scary. Then certain of the lethality factors are more significant than others, and really these are the ones on the quantitative and qualitative list tend to be more significant than those on the environmental list. So strangulation, for example, something that historically we have minimized in our culture a great deal. We call it choking, as though we've gotten some food caught in our throat rather than someone's putting his or her hands around someone's throat. But strangulation brings with it 7 times greater risk that the victim will be murdered. And not murdered by strangulation. That doesn't happen so often. It's just that people who engage in strangulation are willing to take the life of someone, usually in some other way. So strangulation is something that we have, as I said, minimized. Even victims tend to minimize their experience with strangulation. We had a hotline caller not long ago who was pregnant, and the advocate on the phone said, has anything changed since the pregnancy with regard to the abuse? And of course she was trying to see if there was any escalation during pregnancy, and the victim said, oh, no, it's gotten so much better. Since I got pregnant, he only chokes me now. So here she was actually experiencing an increase in the danger. She had been strangled multiple times, even to the point of unconsciousness, which could have long-term health risks to her and certainly health risks to the child she was carrying. But in the victim's perception, it was getting better. So strangulation is certainly something that we need to be paying attention to and taking very seriously. Threats to kill are another very significant lethality factor. Someone who has been threatened with death is 15 times more likely to be murdered by an abusive partner than someone who's not been. So it's really not a case of sticks and stones may break my bones, but words will never hurt me. Words can be incredibly significant. Depression or thoughts of suicide, this can indicate that the abusive person really doesn't care anymore, has no worries, And this could also pose a greater risk for bystanders or children or other people, not just the victim herself or himself. And then the victim's efforts to leave. We have seen this over and over in our local fatality review and also in state of Georgia fatality review, that the vast majority of cases of lethal domestic violence, there's at least planning or preparation or some action taking in terms of the victim trying to end that relationship. And then the last way that we can sort of sift through lethality factors, I think in a quick but still effective manner, is to look for certain combinations. So, for example, looking for the stalking or the jealous behavior, which would indicate more of the intimate terrorist type of dynamic, and then combine that with an access to guns, or combine that with an increase in attacks, or combine depression and suicide with the victim's effort to leave. And so when you look for these kind of potent duos or triads, those can really indicate a much greater risk.
Access to firearms, then, is that also a lethality factor that you consider?
Oh, absolutely. Access to guns poses about a six-fold increase in serious injury or death. And I know that that's a tricky one because, you know, we're in Georgia and a lot of people have access to weapons. And the thing that we have to bear in mind is that having the weapon handy just increases the likelihood that it may be used during a domestic violence episode. That's one thing. Another thing that we need to bear in mind is that neighbors, friends, bystanders, it's been shown in studies, are much less likely to provide aid to a victim of domestic violence when they know that there are weapons in the household. So it actually impacts the victim in two ways. And then if we think about it in terms of the lethality factor combinations, the most toxic one there is threats to kill with a gun. And then we see 20 times more likely to be murdered than a victim of domestic violence who hasn't been threatened in that way.
So if I was going to consider a domestic violence case not through the traditional indicators of severity of the crime, criminal history, but through the lens of lethality factors, can you give me an example of how that might play out?
Sure. So this was a case that we had in Athens a while back that we looked at in our fatality review panel. So it was a criminal trespass. And the victim had moved into her own apartment, and ground floor apartment, and she could see her ex out the window, and he was at the front door, banging on the door, imploring her to let him in. And in fact, ever since she had left the relationship, he had been calling her on the phone, leaving voicemails, you know, please take me back, I'll do anything. He'd been leaving notes taped to her door, leaving flowers on her doorstep. On this particular day, he was out there ranting, and he was saying that if she didn't take him back, he was going to get his aunt's gun and take himself out. So she'd called 911, the police came, they picked him up for criminal trespass. He didn't have any criminal background except for a DUI. So this is a great example of a case that if you looked at it through that traditional lens, you wouldn't think very much of it. There wasn't any weapon actually involved. There was no injury, no violence. There was no criminal history between the parties. So this wouldn't look terribly important or dangerous from that perspective. But if we start looking at this through the lens of lethality factor analysis, the picture really changes. So we've got access to a firearm with the aunt's gun. We've got stalking with all of the notes and the calls and the flowers and all of that. We've got the victim leaving the home, so trying to end the relationship. We've got threats of suicide with that statement that he would take himself out with his aunt's gun. We've got access to victim, the no-brainer lethality factor. He knew where she had moved to. We can infer it from the DUI, but the victim would have confirmed that we have a long history of alcohol abuse on the part of the perpetrator. And then if you had some time to talk to the victim, she would have stated that the perpetrator was unemployed, which is really our most significant environmental lethality factor. It carries a 4 times greater likelihood of death, just by the way. But she would have described that he was unemployed, also that she was pregnant at the time, and finally that the abuse that that she was experiencing had escalated, and that's really what prompted her to leave. So there we've counted up 9 lethality factors, so 2 over the average number of someone who's murdered in a DV situation. And so from that point of view, then the picture changes, and this becomes a much scarier looking situation. And so this is where we really would hope that judges will become familiar with lethality factors and use them as a tool so that when a judge is faced with a decision, what kind of bond conditions should I set? Gosh, there's no DV history here, there's no injury, what should I do? If you look at lethality factors, maybe you'll come to a conclusion to set certain conditions that you might not have reached otherwise. Or if a judge is on the fence about a temporary protective order because the underlying offense doesn't seem terribly serious. Again, if the petitioner has written in examples of lethality factors, if a judge is aware of those, then that might sway a decision there and just give an opportunity to try to increase protection to the victim. Then my question to you really, though, is you have to have access to the information in order to use the tool of lethality factor analysis. So on the criminal side, on the civil side, how can you get the information as a judge that you would need to engage in this analysis?
Well, in Athens, magistrate court judges don't handle temporary protective orders. That's not the case in many jurisdictions. A magistrate court judge might be responsible for those decisions, which are civil hearings. And in the setting of a temporary protective order, at that initial stage, the ex parte stage, that is the stage where a judge is speaking alone with the applicant, you have effectively a confidential conversation with the applicant. There's no other party there, and a victim of domestic violence may well feel more comfortable in answering questions more completely and honestly. On the criminal side, you might never have a situation quite like that, but there are a number of excellent sources of information, I think. The first being that if you're a magistrate court judge, you are also likely a judge who signs arrest warrants. So sometimes I will be signing arrest warrants and know that in the next coming days that I'll be seeing folks for bond hearing. Since the officer has to present probable cause to me in order for me to sign the arrest warrant, I'll also ask some questions about some of these circumstances that might tie into lethality factors and get information that way through the conversation with the officer. Of course, we always have the access to the police report, and a police report can, when well written, can be an excellent source of this type of information. Police report, when it's written rather sparsely, can also sort of hinder your consideration. I have had situations where after setting bond, I found out more about the circumstances than were in the police report and sort of thought, gosh, I wish I had known that when I set the bond. And I've had other situations where I've thanked the officer to say, thank you for including such a thorough description of the events and the history and the circumstances here, because it really allowed me to make a more careful decision about the bond rather than just considering the case on a superficial level. Once the case comes to court for consideration of bond, I always ask our clerks to contact the victim. Again, these cases are typically being seen just hours or a day or two after arrest. And I ask our clerk to contact the victim, not necessarily to know the facts of what went on in the incident, but to make sure that I can hear whatever their concerns may be about bond or the conditions of bond. And so that, I think, is a step that allows a victim, first of all, to be aware that the case is being heard, and secondly, to make us aware of any immediate concerns that they might have. Of course, there are also a fair number of cases where the victim may actually appear in court. So there are times also that, in addition to phone calls with the clerks, that I get to speak directly with the victim in the bond hearing.
Okay. Well, talk about that some more. You know, what is it like when victims appear in court before you? What are they asking you for?
It's a difficult part of my job. Again, when an incident of domestic violence has occurred, you may be talking to a victim within mere hours of that having occurred. And it's very important to me that a victim's concerns be heard and honored by the court system, and at that moment I am the face of the court system. At the same time, in the large majority of those cases, it is going to be the victim's request that I institute minimal, if any, conditions of bond. So I may have a situation where a police report, where the presentation of the warrant includes a lot of very alarming information, and the victim might say, I'd like just to be back at home in the same exact situation tonight. And so the challenge, I think, for me or for any other judge at that point is, again, to make sure that victims' thoughts are heard and honored, but also to emphasize to them that I have the ultimate decision-making authority, and that I can't ignore what I am seeing in the circumstances of the case. Many folks who are victims may have had negative experiences with the court system in the past. And so I hope that when they leave court that day, that at least they've heard from me that I am interested in what they are saying, that I'm concerned about what they are saying, even though I may not enter the conditions exactly as they would wish. Mm-hmm. Now, hearing all that, am I on the right track, or are there other things that I should consider in speaking to victims in the court setting?
Well, you're definitely on the right track, Ben. I think, you know, it's important to remember that domestic violence is usually a crime of repetition. And so, as you mentioned, someone may have already had prior experiences, and it's very likely that someone's going to have future experiences. And so, how a law enforcement officer, how a judge or a clerk of courts, how someone speaks and treats a victim may well impact not only that particular case, but also that victim's behavior in the future in terms of willingness to engage with or call on law enforcement or the court system for help. So it's important to understand that larger picture that we're dealing with. And I think also you get that your job isn't customer service. It's not to fulfill the request of the victim. You have to consider all of that other information. But to listen rather than lecture, to express respect for the person and concern for the person. I think something else that's important to remember is that there may be a whole host of reasons behind what the victim is saying to you in terms of expressing a desire to reconcile or have the abuser come back home. And you probably can't explore all of those reasons and probably couldn't get accurate information in open court about all of those reasons. And so that's where the relationships with other resources or service providers in the community, I think, are really important. Someone may want the perpetrator at home because that's the person who pays the rent. That's the person who is bringing home the financial resources, and it's difficult to imagine how to stay afloat without that person. And so this is where referring to the domestic violence organization that serves The community may be helpful to provide some short-term financial assistance or to go through other options. The victim may be expressing a desire to reconcile simply to stay in the abuser's good graces, to avoid any further escalation. And again, being able to sit with an advocate in private, have a meeting somewhere may allow the victim to express really what's going on. So I do think it's important to minimally connect the victim at that time to a prosecutor's advocate if one is available in the courtroom, but even beyond that, at least have some means of providing the hotline number or some way for the victim to get in touch with a community resource to help deal with some of these other things. And it's really all about remembering the context that your decision about the bond or what have you, that's not happening in a vacuum. Of course, there's all of these other things going on related to the domestic violence situation.
And I didn't say this explicitly, but the first and primary concern in most of these cases is whether or not the defendant will be prohibited from having contact with the victim. That is
Right.
the main issue that I get input on, and my first concern in setting bond conditions. The second thing that I have to consider in cases involving domestic violence or any violence is the possession of firearms, which you touched on earlier.
Right, right. Of course, people in Georgia love to hunt or engage in other sporting activities or just have guns in the home to protect themselves, so it's pretty widespread. And yes, we already know the statistics in terms of access to weapons or threats of violence with weapons and how particularly dangerous that can be for victims of domestic violence. One thing that we do at Project Safe on the civil side of things is when we're helping petitioners in TPO proceedings, when we're aware of firearms that the respondent possesses, we will go ahead and write that on the judge's order, basically asking the respondent to turn over the known firearms to law enforcement. There are Brady Act provisions that, of course, limit TPO respondents' ability to purchase or possess a firearm, but those don't kick in until after the second hearing. So we do this at the ex parte stage to try to provide an added measure of safety and accountability, and we find that law enforcement around here is happy to enforce it, and that judges here are willing to sign those orders. But speaking about orders, I mean, you set conditions in your orders, and they're always followed, right?
Unfortunately, that's not the case. That would make life a lot easier. I do think there are a lot of people who do follow and honor the conditions that are set, but there certainly is a significant population that do not, particularly those no contact, stay away orders. Fortunately, the law now has a mechanism for enforcing bond conditions more quickly and thoroughly. For years, it's been against the law to violate a temporary protective order, that is, to have contact with a person in violation of a protective order, which is the civil order. The law was expanded to include both conditions of bond and conditions of probation, meaning that if a condition of bond or probation prohibits you from having contact with a person, from going to their workplace, from going to their home, or from coming within a certain distance of a person, and you violate that order, then that now is a misdemeanor offense, just like violating a temporary protective order. So what you have to have for a violation there is you have to have an active condition and you have to have contact. It is not a defense to that statute that the contact is consensual. So in those cases where a victim has voluntarily allowed contact with the defendant, that doesn't mean that the defendant then has a defense and that it's not a crime. So what this does ultimately is eliminate the old process, which is, say an officer discovers that a defendant has been contacting a victim. They contact the prosecuting attorney. The prosecuting attorney files a motion. Judge sets a hearing on the motion. We have our hearing. Weeks, probably at best, have passed. Now the officer has authority to arrest immediately upon his observance of a violation, or of course just to present a warrant to the judge for arrest of the defendant at a later date.
Mm-hmm. You know, when we work with TPO petitioners, we certainly explain to them that only the respondent is subject to the conditions of the order. That is, the TPO only restricts the liberty of the respondent. But we also counsel them that just as a practical matter, that petitioners need to be willing to participate in upholding that order. So in layman's terms, they really have to be willing to break up for at least a year to not have contact and to try to resist the you know, what might be a very strong pull on the part of the batterer to try to reconcile. But with 16.595 expanded to include bond violation, does that open the door in any way for victims to be arrested as a party to the crime of the violation? Absolutely not, from my perspective. And one of the things that I emphasize in the bond hearing is that this order controls one person and one person only. So say if there's a victim present in court, I want them to know that I am not entering an order against them. And that goes for conditions of probation, TPOs, violations of bond. There is only one name at the top of each of those documents, and there's only one person whose behavior is controlled by each of those documents, and that's the defendant. And ultimately, I think there can be situations where it may be frustrating if a victim were to choose to have contact with a defendant. But if you consider that in the context of some of the things that you've been talking about control, and in the sense of the narrowness of these orders, that is to control the behavior of only one person, I think it'd be completely inappropriate to arrest a victim based on a protective order where they were the applicant, or a condition of bond or probation where they were the victim. Mm-hmm. All right. Good to know. Now, one thing that as I go and make the difficult decisions about bond, one thing that makes my life easier is the fact that in Athens, many of the cases that I see for bond hearings will be reviewed by a judge in 10 to 17 days in state court. We have what we call the fast track system. Normally in Athens, a case that is set, where a person is arrested, their arraignment date, their first court date, might be set 45 to 60 days from the arrest date. We've developed a system in conjunction with the state court judges, the solicitors, that if a case meets certain criteria, it will be placed on the fast track calendar. One of those criteria is a previous arrest for domestic violence. Another one is whether or not the offense includes a violation of TPO, and whether or not the offense includes an allegation of stalking. Any of those circumstances would lead to the case being placed on that fast track calendar 10 to 17 days away. We also, as magistrate court judges, have the authority to place any domestic violence case on that calendar. So if I see a case where the conditions of bond have been particularly challenging for some reason, or if there's just legitimate issues on both sides that are going to have to be addressed sooner rather than later, I can place the case on the fast track calendar so that a state court judge can see those issues sooner rather than later. And as the fast track calendar plays out, Joan, I know that you all are involved through Project SAFE with the fast track calendar as well. How does that work out for you? It works out really well. It's predictable. It's always on Friday morning, so our advocates know where to be. And quite often the victims are there at the fast track arraignment, and so we have an opportunity to speak to them at that time. Because we review domestic violence arrests in our counties and then reach out to the victims named in the reports, often we've already made contact or attempted to make contact with the victims at that point, but this gives a chance for a face-to-face meeting to at least learn about services that are available, to try to hear from the victim about what needs we could try to meet. So that works out really well. It's also not just us, but other community providers too. So for example, the Temporary Protective Order Clinic at the law school, their managing attorney is always there for fast-track arraignments as well. And you know, I would argue that your discretion includes placing cases on there when there's a number of lethality factors too, because any time that we can speed up the process of accountability, certainly reducing the time from arrest to arraignment from 45 to say 10 days, anytime we can do that, we are closing a window of opportunity for the abusive partner to try to woo the victim back with promises to change and do better, or manipulate or threaten the victim back with you know, more dire sort of consequences if the victim doesn't disengage from the prosecution process or something like that. And so in these serious cases, we are just all about utilizing the fast-track process. If I had my way and we had the resources, all DV cases would be moved to fast-track, but I understand that that's just not practical yet. But fast-track was something that was really born out of work in our domestic violence task force, and that's been so productive for our community here in the Western Circuit, Oconee and Clark counties. We have a very active task force. We have since 1998. And this is where a lot of our creativity comes out. A lot of our collaborative processes began in the task force. So fast track, our fatality review process, which then led to our case staffing process, where we talk about cases that are non-fatal but that we're still very worried about, and take a multidisciplinary team approach to dealing with that. We also tried for a number of years ago in the task force process to get lethality factors actually added to the arrest reports at the police department in Athens, Clark County, and we found that the software couldn't be customized for certain kinds of reports and not for others, and so we weren't able to do that. We wound up printing pocket-sized cards, laminated cards that had the lethality factors on them as a prompt to help law enforcement officers remember the factors to put into their reports. And then we also met with judges at the time and asked them to specifically ask officers, or at least give positive reinforcement when they see factors in the police reports, and it helps them make decisions. And I know you've done that as well, haven't you?
I do. I always, as I've mentioned, am appreciative to officers when they include that information in a report. And I've had to say a couple times to officers, gosh, I wish I had known what you're telling me now in presenting the warrant. I wish I had known that when I was considering the bond in the case. The reality is that sometimes in magistrate court, a magistrate judge might serve as quality control on the police reports that are coming in the door, because if they're not written well, judges will lack the information they need to make the best decisions that they can.
Right.
And I think the officers are sincerely interested in judges having that information. Sometimes they just have to put it on paper and think it through a little bit.
Absolutely, and that's certainly something we've learned in the task force process over the years too. Is, you know, we all have this role that we play. We're all really important parts in the broader community process of trying to increase safety for victims and accountability for perpetrators, and hopefully ultimately reduce domestic violence. So the more that we can interface and communicate and help each other do our specific roles in a better way, the better off we all are. And you know, task forces are really a great way for judges to become more involved in the community processes around domestic violence. And so in some jurisdictions, judges are very active, sometimes even leading the task forces. In other communities like ours, judges aren't as involved but may monitor the listserv or ask to participate in an ad hoc basis around certain initiatives that really get developed.
Joan, thank you for our time here today. I've enjoyed this and all of our other discussions on the issue of domestic violence. I believe that many judges around the state of Georgia face some of the same challenges and concerns that I have, and hope that you all have benefited from our discussion here today, and will continue to explore some of these topics to make the best decisions that you can as you confront these challenges on the bench.